Welcome back to Kapowich on Real Estate. This is a show dedicated to consumer protection within the residential real estate arena. We began this program at De Anza Community College in Cupertino, and we started with programs on financial elder abuse surrounding the real estate property. And then over the years, it has morphed into other areas of older adults living at home, and not only just their home, but their spouse, their adult children, and their resources. And to make more sense out of that, we have a certified elder law attorney in the studio here tonight. We have Janis Carney at Carney, Sugai, and Sudweeks, who have written this great book, Protect Your Family, Don't Write a Blank Check to the Nursing Home. What a great title.
Thank you.
Thanks for coming on tonight.
You're so welcome.
The other part of this book at the bottom, it says, we've cracked the code on long-term care planning.
Correct.
Okay.
That's what we think.
Excellent. So, and that's what I hear out in the field at being a realtor is, if my grandmother or my father goes into a nursing home and they wind up on Medi-Cal, will the state eventually take their home?
Well, that's a complicated answer. You need to start by understanding what the Medi-Cal rules are. Okay. And so if your dad is in a nursing home, a skilled nursing facility, because many people don't understand that when your dad is in an assisted living, that's not what we're talking about. Medi-Cal doesn't pay for an assisted living facility. They only pay for skilled nursing. And so if your dad's in a skilled nursing pad, he will, if he cannot pay for it himself, and there's no other source of payment for the skilled nursing home, he can go on to Medi-Cal. Now, Medi-Cal, he has to be financially needy, but under that he can have certain assets, and one of which is the house, and still be eligible.
Now, I believe the spouse can still have resources.
The spouse can still have, the financial need is calculated. Your dad, who's in the nursing home, can have $2,000 of countable assets, and your mom can have another $113,560,000 of countable assets. In addition to the countable assets, they can have any value in California currently of exempt assets. Exempt assets include the house, the retirement accounts, the one vehicle, the reasonable personal furniture, furnishings, and that kind of thing, personal effects. And certain other very limited availability assets. If they can qualify for Medi-Cal, they can keep those assets while they're in a nursing home. But when they leave a nursing home, there's a problem.
Now, from my studies, learning more and more about older adults, the greatest generation, 25% of them say have the resources to go into retirement and take that money will last their life. But for those who don't, that don't have the resources, they can use Medi-Cal.
For their long-term care in a skilled nursing facility. Many people hope never to have to go to a skilled nursing home. They're very, very expensive.
Now the other option there was the long-term planning, the insurance.
Sure. They could buy long-term care insurance if they were healthy and young when they bought it. But the greatest generation, as you said, are now 80 and 90 years old, and they're way too old to qualify for. They were too old when long-term care insurance became readily available.
Now, we've joked in the past about the acronyms in this, the LTC, long-term care. Insurance. Now, for the older, for instance, now the silver tsunami, beginning in 2010, we have up to 10,000 baby boomers a day, turning 65. Maybe some of those have used this insurance.
Potentially. Some of them have it. But most of the time, the long-term care insurance isn't going to be sufficient to pay for the whole cost of long-term care.
Right, you've mentioned that in the past.
At-home care costs or skilled nursing facility costs are just too great. It might pay or help pay, along with their other income, for assisted living.
Okay, let's touch on that, because the theme of this program is aging in place, and that's become a cottage industry. We have young people that can be hired, they'd be vetted, they'd be fingerprinted in a background check, and come to help grandmother or your dad walk around the block or go to the store.
And there's many agencies, very reputable agencies, who will help with home care. Matter of fact, I heard recently that there were about 85 home care agencies in Santa Clara County now.
Wow.
So you have to be very careful in vetting the agencies, because they're not all created equal.
Right. And it's become they have franchises like a 7-Eleven or a pizza parlor, covering zip code.
Absolutely.
Now, and what's important about that, and we'll move along, is are the workers vetted by fingerprinting and their background checks? Some are just
ought to be,
they ought to be, but some are just having background checks and not. So there's different levels of having them vetted. We have spoken in the past. It's very confusing about Medi-Cal, Medicaid, Medicare.
Yes.
Can you briefly touch on that? Yeah, I know we could do a show on that, but
that's very common that my clients are confused about that, or the family are. Medicare is the health insurance you've paid into during your working years. When you turn 65, you qualify for Medicare. It's health insurance. It's going to cover your medical expenses.
okay.
Medicaid is a federal needs-based program that, when you don't have other health insurance, and if you are under certain categories like children, or you're permanently and totally disabled, or you're over 65, you can qualify for Medi-Cal, Medicaid. Here I am
Right.
getting all the words mixed up. Medicaid. It is a federal program that is operated on the state level. A state must have a program for the Medicaid, and each state can modify the rules a little bit, and the program can be called whatever the state wants. In California, the Medicaid program is called Medi-Cal.
Right.
So we don't technically have a program called Medicaid in California. It's the same program, but it's Medi-Cal.
Okay. Now, speaking of the qualifications of Medi-Cal, how does grandmother or my mother qualify? There's a certain routine that has to take place.
So there are various programs under Medi-Cal. Let's stick with the long-term care program.
Okay.
The long-term care program, which I said already, is only going to pay for a skilled nursing home. They have to, as I said, be over 65 or permanently totally disabled and in a skilled nursing home in order. Those are sort of the base things. Then they have to be financially needy. The state's going to divide their assets into two categories: exempt assets and countable assets. The exempt, as I said before, are primarily the home, the retirement accounts. There is a little quirk on the retirement accounts in that the person who's in the nursing home, the retirement account has to be in payout mode. So you have to be making distributions from it.
I see.
Even if they're younger, even if they're under the tax threshold of 70 and a half when they have to start taking it out.
Now, in the application process, don't they have to verify that they do plan to return home?
The home is going to be exempt if a number of different categories or characteristics are fulfilled. One is that the applicant intends to return home. This is a very subjective test. It's not objective. It doesn't mean that grandma or dad will ever realistically go home. But as I ask my clients, if God made you well, would you go home? And of course,
Most
the answer
of
is
them
yes.
will.
Nobody's
Right.
going to stay in a nursing home
Right.
if they don't have to. So it's very easy to check the box and say, I intend to return home. But there are several other ways. If your spouse is in them, you have a child under 21 in the home, or other dependent relative, if you have siblings who have an equity interest in the home and they're living in it, or there's one other, if the son or daughter has been there
for
at least a year,
right,
then it's going to be considered exempt. Now, when I say exempt, Pat, it's really important that we understand it's exempt for Medi-Cal eligibility purposes, because once a person dies, it's not exempt when we go to talking about recovery.
And that by recovery, that's the basis of this show, Will the State Take My House, which I've often heard about.
Exactly. So they don't take it in the front end, but they might take it on the back end.
Now, there's another thing. Once they are in this facility, isn't annual, they have to go through the paperwork again? Don't they? Once a year?
Yes, you go through their assets, and if their countable assets are below the thresholds of $2,000 for the applicant and $113,560 for the spouse, and everything else is exempt, then they'll qualify. But once a year, the county is going to relook at what they have. Maybe they've sold the house. Maybe they've taken a bunch of money out of the retirement account and now it's in a regular account and it's no longer an exempt asset. So if they have too many assets on an annual basis, the county is going to determine whether they're continue to be eligible.
And that's where a member of the family goes to the county building, sits in a cubicle with that official.
Right, you do that at the beginning, and well, that's the way they used to do it. Most of the forms are now online, so you can go online and apply, or you can still go into it. When we do applications for clients, we always go into the building. It's better to have a face-to-face.
Oh, absolutely.
Sure.
Absolutely. And then in terms of the surviving spouse is staying at the home and just waiting to see what happens.
Well, usually.
Okay.
That's going to be the situation. Once the deceased spouse, once the ill spouse who was in the nursing home,
the ill spouse, excuse me,
the ill spouse passes away, okay, then the state's going to determine whether or not there's going to be a recovery claim right away or later. If the ill spouse who was in the nursing home is not married when they die, then the state will make a claim right then against anything the ill spouse owned when the ill spouse died. Now, what is it that they own? They own anything that's in their name or was in a revocable living trust for them. So they own all those assets, and the state can make a claim against them to get the money back that they paid for the person. There's a couple of situations where they don't get it back right away, and that's if the person was married and they have a surviving spouse, then the claim is deferred as long as that spouse is living.
Right, so the surviving spouse can stay in the house as long as he or she wishes.
Right.
Okay.
It's also deferred if the ill spouse, the former person who was in the nursing home had a disabled child. And disabled means someone who basically would qualify for Social Security disability benefits.
Sure.
And if that's the case, the claim may be avoided altogether.
Wow.
Timing is of the essence there.
Now, is there any way to avoid the recovery claim altogether?
Well, only if you have a disabled, if you do planning.
Okay.
But if
With
you haven't
planning.
done planning, the only place is where there's a disabled child. So our firm and elder law attorneys are knowledgeable about the rules, about what you can do with your assets, and still be eligible for Medi-Cal or Medicaid if you're in another state. In essence, the assets are taken out of the ill spouse's or ill person's name. Maybe we put them into the well spouse's name, maybe we put them into an irrevocable trust. There's a number of different things we can do, but the person who was in the nursing home cannot own those assets when they die. So this is what we do. It's very complicated in doing these transactions
Sure.
because, as you know, as a real estate agent, there's so many tax issues that wrapped up with property. We were talking about Prop 58 and Prop 13.
Sure.
You know, we don't want to lose our assessed values if we can avoid it. There may be capital gains issues, all of those kind of things. You don't want to, you know, what is the saying? Cut off your nose to spite your face,
Right.
kind of thing. So you got to be careful and in what you do, and know what it is that you can do.
Now, we have seen this in the past where older adults often, and I go to their homes, and I've seen this, and with my clients' families, is they've waited too long. And that there was a window when they could have moved to an active retirement, or if there was, say, grandmother had dementia, that they could go together to a facility where there's a memory care unit as well. But sometimes the family stays in there so long, of course, with family members helping as caregivers, which is the largest unpaid profession in America now, over 15 million caregivers. So that's part of it. Oftentimes when they're spending so much time with this 10-year, 8-year cycle of dementia, Alzheimer's, that this planning may have taken a back seat.
It usually does. Most people come to us when there's a crisis looming.
Okay, and attorneys, elder law attorneys always talk about the crisis moment or the crisis, there's a catchphrase, I think, that elder law
that we use.
Yeah, well, the family's in crisis. Excuse me, families in crisis.
Families in crisis.
Right.
And so when the family realized that mom can't be cared for, the money's running out, or the mom's going to need to go to a nursing home now, and they're seeing the cost of the nursing home and how grave it is, they oftentimes come to us and say, we've heard that there's something we can do. What can we do to protect mom's assets or to provide for mom? If she doesn't need a skilled nursing home, oftentimes they come just because mom's running out of money. She can't afford those home caregivers anymore. And so we're counseling them about what can be done, if anything.
Now, of course, pre-planning is something we can. Now, a lot of older adults don't want to have these conversations, so their adult children can come in by themselves to an elder law attorney.
They can. It's really complicated because who's the client?
Oh, I see.
And whose assets are we talking about?
Right.
They're moms and dads. We're not talking about that. But the kids oftentimes come in and they say, Mom wants me to come and find out about these things. Or they probably had a family discussion and the capable child is sent off to find out all about this stuff and they've come in to talk to me. So I will talk to families, to the child, you're coming in to talk to me about your mom and explain the rules.
In general?
Well, even with specifics about your mother, because you brought all of the specifics to me. Okay. And I'll explain what can be done, but I'm always looking at the case on behalf of your mother. Right. What's in her best interest. Sure. And I want to make sure that you are a good son and you're going to make sure that your mother's well taken care of.
Now, that said, oftentimes, let's say there is multiple siblings and the parents have to choose a child or two to run the estate. That could be problematic too.
Well,
you need to have a meeting of the minds there.
It can be. How do you get along? How well do you get along with your siblings?
Okay.
So that can be, but usually, well, I would say it's the the vast minority of the cases that there's going to be problems.
Okay. So for the viewers that just tuned in, this is certified elder attorney Janis Carney, and we are speaking about aging in place. And I wanted to touch on you have written some tidbits about the myths and misunderstanding about long-term care planning.
Sure.
So let me just hit this here as we go along. Now, you touched on it before, but Medicare pays for long-term care.
No, it doesn't pay for long-term care. It might pay for a skilled nursing home for a period of time. Okay. Like if your mother broke her hip, she goes to the nursing home, she needs rehab, she's in there for medical reasons, then Medicare is going to pay for that up to a point. The basic Medicare will pay for up to 20 days, the full amount for up to 20 days of care. Then it will pay just a portion of up to another 80 days, but there's no guarantee that you get all of those 20 days or all of the additional 80 days. Mom has to be getting better, has to be medical. If she gets to the point where she can't get any better and you say, well, she can't come home because she needs too much custodial care,
correct,
then it turns into long-term care, and Medicare does not pay for that at all.
Okay. Now, Medi-Cal allows me to give away $10,000 a year.
No, not at all. That's a tax rule. That's, you hear all the time, well, I can give away $10,000 or $13,000 a year. Now, it's a gift in a state tax rule. Has nothing to do with Medi-Cal.
Mm-hmm. Okay, I have to spend or give away everything to get on Medi-Cal.
Well, we just talked about it. We don't have to give away the house, the retirement accounts, the personal properties. You might need to get rid of them before you die so that there's no recovery claim against the house. Matter of fact, there is no recovery claim against a retirement account, assuming you have named beneficiaries other than your estate on those retirement accounts.
Now, touching on that, I've heard this in the past about I have to wait 5 years after giving everything away before I can get on Medi.
That's a confusing thing because the federal Medicaid program has what is called a 5-year look back. In California, it's really only 30 months. California has not adopted the federal rules to the extent of that they are. So in California, it's currently only 30 months. And if you give away assets during that period of time, there is a consequence to it. Meaning? The consequence means that Medi-Cal won't pay for your skilled nursing home for a period of time that the money or the whatever asset, the value of the assets you gave away, the gift would have paid for a skilled nursing home at the private pay rate in the state of California from the time you made the gift.
Okay.
So it's a complicated calculation, but you can certainly get still on Medi-Cal even if you've given assets during that time period.
So the lawmakers, it seems to me, are aware that people have been told, get rid of your assets, abandon ship with your assets, give them to your offspring. And so they have this
Well, matter of fact, Medi-Cal, the Medi-Cal office and the caseworkers have to send out notices to the people on Medi-Cal that warns them that if they own those assets when they die, Medi-Cal will have a recovery claim. It basically warns them to go and find out what you're supposed to do about it without telling them outright to go do it.
Wow. Okay, a living trust protects my assets if I need Medi-Cal, if I go into a nursing home or on private pay.
No, a living trust doesn't protect your assets at all. Okay. All of the assets in a living trust are available, but many clients don't understand the differences between types of trusts. And so they've heard, if I put my assets in a trust, they'll be protected. That's not the typical revocable living trust that most people have.
Okay, now the nursing home can evict me when I qualify. If I run out of private pay, can the nursing home evict you?
No, they can't. Under California law, matter of fact, under federal law, if you are in a facility that accepts Medi-Cal, and actually probably 98% of the nursing homes in California do accept Medi-Cal. And if you run out of money and you need to go on Medi-Cal to pay for your nursing home, the nursing home is prohibited from evicting you.
Okay, because we've heard these stories nationwide
Yeah,
about come and get your son or come or your father rather.
It doesn't mean that they aren't going to try to dump your dad.
Oh, right.
There's a lot of scandal around that going on right now. The nursing homes, while they're prohibited from doing that, the consequences to them are not very great from the state in penalties and such. And so some of them try to do it. Fortunately, you know, Pat, I have found that most of the people in nursing homes are pretty honorable.
Sure,
If we go in and we say, no, you can't do that, you've got to take care of Pat's mom, they're generally going to do it, as long as they are getting along well with you.
Sure, right. Now, we hear a lot about older adults, widowers, getting married, and they might have a prenup. So we're going to wrap up with this. With the prenup, will that protect my spouse's assets?
Oh no, and that's. I've had actually spouses in the office getting angry at me, but they were supposed to. The prenup was supposed to keep everything separate and protect the assets. When a person goes on Medi-Cal or applies for Medi-Cal, Medi-Cal's going to look at everything, both the person in the nursing home and their spouse own. Yeah. So it's all going to count. Now later in that yearly renewal time that I told you about, they don't count the spouses, but you got to get past that initial time.
More bad news for prenups.
They don't work for Medi-Cal planning.
Janis Carney, certified elder law attorney, thanks for coming out. Here's her book. We'll see you next week. Thanks again.